Hi, I'm Henny Bushra. I'm an immigration attorney in Huntington Beach, California. Today is June 26, 2020. I just want to make a short video about the Supreme Court ruling yesterday on June 25th, 2020, because I had a lot of questions regarding its applicability to some of my asylum clients and some people who are in asylum process. I just want to specify that this ruling deals with a very specific set of facts that a lot of people who are watching me right now are not applicable. It's not applicable to them. It deals with people who are in something called credible fear. It's somebody who is also in a process called expedited removal. Most people are not in expedited removal, at least the people who are listening to me right now. Expedited removal happens when you are caught inside the border of the United States within 14 days, I'm sorry, not 40, 14 days of your entry to the United States. And you are undocumented, you don't have any documents, and you express fear of going back to your country. You're giving something called a credible fear interview. A credible fear interview is a very low standard interview, and if you cannot pass that, you are not allowed to apply for asylum. Now, the credible fear interview for this person who the court ruled against yesterday, the credible fear interview that he got, the immigration officer that met with him decided that he does not have a credible fear interview. This was appealed to a supervisor, and then it was appealed to an immigration judge. All three entities said that this person does not have a credible fear of returning back to their home country. This person who had the credible fear denied appealed to something called the federal courts and asked the federal court to review the decision of the immigration judge. Now, the ruling yesterday said that the federal courts have no authority to review the decision of the immigration judge. Now, for most of the cases, or are listening to me right now, are people who came into the United States with documentation, whether it's a visa, whether they were here through an H-1B visa or a tourist visa, or were here for a while. That's number one. Number two, they have applied for asylum. They are in the Asylum Office. And number three, okay, they are not undocumented. They have a document which is the application for asylum. Now, for these people, the process is as follows. You are gonna if you don't succeed in the asylum office, you are going to be able to go to immigration court. Yes, we do call it court, but it's different than the federal court. It's still within the administrative branch. After the immigration court, you're allowed to appeal to something called the Board of Immigration Appeals, which is also within the administrative branch. And until now, your right is even preserved even after the Board of Immigration Appeals, if they deny you, to go to the federal courts. And so for the most of the people who are listening to me right now, this is not an applicable situation to them. It's not good news for asylum seekers generally. It just shows that the tendency of the Supreme Court is to limit the rights of asylum seekers, but at least for a lot of the people who are listening to me right now, their rights are not being affected. If we can help you, if we can answer any of your questions, please do not hesitate to contact us. Our contact information is all over the page, and thank you very much. Bye-bye.